Well, North Carolina's Public Records Act provides for public access to government records. And the Act lays out a process for requesting and, when necessary, suing for access to public records. However, according to our guest, Elliot Engstrom, there are several areas in that Act, and it's interpreting case law that presents some problems and some inconsistencies. These problem areas are barriers to both public access and government efficiency. So today, we are delighted to have with us the fellow at the Elon University School of Law, Elliott Angstrom. Please welcome Elliot.
Okay, give me one moment here to get myself situated. Okay. All right, well, thank you all for coming today. I know that y'all are busy people with a lot to do, and so my presentation today is basically a quick look at the research I've been doing on public records laws for a few schools around North Carolina, for Elon and Chapel Hill. And in lieu of going really deep into any particular topic, we're gonna kind of skip across the top of a few topics. So you're going to learn a little bit about a lot of stuff instead of a lot about one thing. That's good for you, because if it gets towards 12:50 and I'm not done, we're just going to stop, and we're just not going to get into the last few topics, because I know y'all have things to do. So I'd first just like to, I bet most people in this room are sort of familiar with public records laws, but I want to make sure we're all starting from the same place. And so public records, the point of this statute up here that I've got, I want you to understand that public records is not just paper, right? Public records is videos, voicemails, emails is a big one, and emails is one that that's some new research I'm starting now, is on how do we deal with emails, because it's very difficult. The public record laws were written for paper, not for emails, and we're having to deal with that. But it's a lot of different things. It's a lot of different kind of records that are in the possession of government. They're actually, you notice this language right here, in connection with the transaction of public business by an agency of North Carolina government. There was some litigation about, does that necessarily apply to all records, and it does. So that's not a limitation. So public records are all the stuff, kind of an informal way of putting it. It's all the stuff except for the exemptions that are in the law. And so there's exemptions, for example, for you can't request as public record UNC's emergency response plan for when there's a shooter on campus, right? You can't get that as a public record. That makes a lot of sense, because we don't want somebody to be able to look at that beforehand and then go, all right, I got your plan, right? And there's a lot of things that fall under exemptions that we're not going to get too much into today, but if it's not under a specific exemption like that, it's a document made or received by government, it's public. And by the way, there's probably some people in this room who are the types that will email their senators, email their state representatives. Emails to governments are also public records, right? So you are in many ways subject to this law, even if you don't necessarily work for government. I could go to Senator Phil Berger's office and say, Senator Berger, I want all emails you've gotten from the John Locke Foundation over the last month. And I could get those, right? In general, the laws around public records are a scheme that dictates when and how people access these records, right? And they generally provide the records are open to inspection by any person upon request, with certain exemptions. Again, there's a lot of exemptions. That's a whole other thing, talking about what things are exempted and what things are not. Any person does apply to any person, so you don't have to be a North Carolinian. This is something that's being thought about by a lot of states right now, is should we give people in our state preference? Again, another issue. So we have public records, basically all the stuff made or received by government. We have public records laws that talk about how do you access all the stuff made or received by governments. And so when you hear public records lawsuit, that's when there's a requester and a government agency disagree as to whether this thing is a public record, right? Government agency says, nope, not public. There's an exemption, so we don't have to give this to you. Requester says, oh, yes, it is. And so you go to court and you fight about it, right? You go to, by the way, civil superior court, so it's a real lawsuit, and it's pure statutory construction. And so some of y'all who are familiar with agencies know that agencies get deference when they're interpreting their own laws, right? So the Department of Environmental Quality in North Carolina, if they are interpreting a statute dealing with the environment, a court will defer to them. Courts don't defer to government's interpretations of public records laws. That means it's pure statutory construction. You go to court and you fight about the meaning of a statute. And a good public records scheme, and this is just my idea, but I think it's a good idea, is you want to have openness, right? But you also want to have predictability and efficiency. And predictability and efficiency, I think, we all know that for plaintiffs, for people wanting government records, openness is always good, right? Predictability and efficiency are obviously good for governments. I think they're also good for requesters of records, so you don't spend years and years and years going after records. Hopefully you can get access more quickly. Also, when governments are spending time going after public records, they're also spending money. That's your money, because you are taxpayers. And so the more efficient we can make this, the better, right? If we end up litigating something for 2 years and nothing comes of that, that's a lot of wasted time, a lot of wasted taxpayer money. And so we're just going to go through quickly a few problems I've looked at. Again, we're not going for depth today, we're going for breadth. If you see anything that you go, oh, I'd like to know more about that topic, then we can talk about that, absolutely, at another time. So one problem, who is the custodian of a record? And we're going to talk about why is this a problem in the first place. So you need some background first for the non-lawyers in the room. There's rules of civil procedure for lawsuits. These are just the rules of the game when you go to court, right? And clever lawyers play all sorts of clever games with the rules in order to win for their client, right? And there's a rule called 12b. And when you go to law school, within the first 2 weeks of civil procedure, you learn about Rule 12b. And Rule 12b is what the defense uses to get the lawsuit thrown out. They'll say, this is a ridiculous lawsuit, get rid of it, right? And they'll move pursuant to Rule 12b. And here's 3 examples of reasons that a lawsuit can be thrown out pursuant to Rule 12b. Lack of jurisdiction over the subject matter, which means the court says, I have no business deciding this dispute, or there is no dispute. And so I'm not going to waste my time with this. Failure to state a claim. If you're going to sue someone, there has to be a legal basis for your lawsuit, right? You can't just make up a claim. And then third, failure to join a necessary party, right? Although that one gets a little more complicated. The point here is that if you sue the wrong person, your lawsuit can be thrown out. And so if we're suing governments, we got to think, well, who's the right person to sue? There's a lot of people in governments. There's a lot of people in these agencies. And so a necessary governmental defendant, when you're suing the government, when you're suing an injunction against the government, is the defendant must, where a plaintiff seeks an action requiring the defendant, the government, to take an action involving the exercise of governmental power, the defendant must be named in an official capacity. And so you think, oh, well, that's easy. The person I'm going after, I'll just name them as a defendant, right? Well, who's the right defendant in a public records lawsuit? And the answer is the custodian. And so again, you might think, oh, easy. I want public records. I just figure out who the custodian of the records is and I sue them, right? This seems simple. Well, first off, we have a statute on point defining who is the custodian. So if there's a record I want, I have to figure out who's the custodian of that record. Ideally, request it from them, and if they say no, then sue them. The public official in charge of an office having public records shall be the custodian thereof. So, the public official sounds like the is an article that refers to a specific person, right? Public official sounds like a natural human being. Person in the law can refer to a corporation, an agency, all kinds of stuff, right? This is public official. In charge of, who's in charge, and then office, who's the office. And again, you might be sitting there thinking, this still doesn't seem that complicated. I'll just figure out who's in charge and sue them, right? Well, here's an example. A couple years ago, I was in litigation with the city of Belmont, and I wanted this. I wanted an investigative report into the city's police department. And the question was, who is the public official in charge of the office holding the report, right? And so there were a few possibilities. The city manager commissioned the report. The city is the agency that paid for the report, the city of Belmont. The mayor is the person in charge of the city. I think you could probably make arguments that each one of these is the proper custodian, right? I argue that it was the city manager of the city itself, and the judge ended up saying that the city is the custodian, which doesn't make a lot of sense to me because the statute says the public official. A city is not a public official, right? And I was actually kind of scared when I got further into the lawsuit, thinking, what if they sue the mayor as the custodian? Because the mayor is in charge of the city, right? And I didn't sue the mayor. Because the person I dealt with was the city manager. The point of this is just to show you that this isn't just an automatic, oh yeah, they're in charge, I'll sue them. You got to think about this. And so ultimately what lawyers will end up doing is just suing everybody who could possibly, be the custodian, and then you got to take the time of going through 12B hearings to figure out who's going to get dismissed from the lawsuit, right? And that's time and that's money. And so here's another example, Klein v. Hoke. Some of you may remember District Attorney Klein from Durham County had some problems with the bar a few years ago. And so the plaintiff was District Attorney Klein, and she was trying to get emails from her time at the Administrative Office of the Court, some employee emails. The defendant was represented by Attorney General Cooper's office. And the question was, who's the custodian of employee emails at the Administrative Office of the Courts? Who is in charge of the office holding the emails of an individual employee? And so the plaintiff had dealt through the entire time, she had dealt with either the AOC General Counsel, and by the way, the Administrative Office of the Courts is an agency that just sort of makes the courts go, for lack of a better word. So the plaintiff had dealt with the Assistant Director of the AOC throughout the entire process. The Assistant Director of the AOC responded to her public records request, sent her emails, and also the General Counsel. Defendant says individual employees are custodians. You can't sue the agency, somebody high up in the agency for emails. You have to go after the individual employee. And since there's regulations saying that employees have to retain emails, they must be the custodians, right? And I want to remind you before this next slide, plaintiff is a lawyer. Plaintiff is a relatively smart lawyer. Defendants are lawyers, and they also are relatively smart lawyers. Court of Appeals says, you're all wrong. All of you are wrong on who the custodian is. The court said, the public official in charge of the office is the custodian of records. Well, that's got to be the director of the AOC. You didn't sue the director of the AOC, so your case that has made it all the way up to the Court of Appeals is done. And you have to start over from scratch. Waste of time, waste of money, right? And so I want to show you, this isn't just in one case. So for example, we have a case out of Kitty Hawk, North Carolina, saying that, and the text I really care about is the big text at the top, but custodian could be a bunch of different people. Court said, well, you sued a whole bunch of people, so yeah, you named the custodian. That's what the court said. We also have a case that we just talked about, Klein v. Hoke, that it's one specific natural person. It's the person in charge of the agency is the custodian. And that's District Attorney Klein. We also have a case, by the way, same year, 2014, dealing with the exact same agency, the AOC, saying that actually the AOC is the custodian of its records. Even though it's not a natural person, it's the custodian of records. This is the view also taken by the judge in the Belmont case. They said the city of Belmont is the custodian of the city of Belmont's records. As the lawyer at the time in that case, I said, fine, whatever, you gave me a defendant, I don't care. But as the academic looking at it now, I kind of think that doesn't make sense. And then lastly, we have an Attorney General guide to open government that says each office should have a custodian, which makes it sound like you just kind of pick your custodian, right? That's not right. This isn't the official guide to open government issued by the AG's office. That's not correct. And I haven't found an updated version of this. Maybe they'll update it. And so that's one problem. I'm going to get into my solutions in a second. That's one problem with custodians, is just figuring out who do I sue, right? Because right now you basically just have to take out your legal shotgun, shoot at everybody you can, and hope you hit something. So also we have this other problem, non-custodian records officers. And so the duties of a custodian under the public records law are to provide access, right? Who actually does that? The director of the AOC does not spend time dealing with public records lawsuits. The governor, the attorney general, the head of DEQ do not spend time dealing with public records lawsuits. These are the people who do this stuff. And any of you who have filed public records lawsuits have noticed this. You work with people called public information officers. And so, for example, NC State actually tells its employees, you cannot give out records until you get the okay from the public information officer, right? UNC Chapel Hill forwarded to the public information officer. City of Greensboro has a public information officer. These are the people who make these decisions. These are the people who you're fighting with over the records request. And if you're a pro se plaintiff, who, by the way, I should have mentioned before, a lot of times public records lawsuits are not being brought by giant law firms. These a lot of times are pro se citizen plaintiffs who are trying to keep their governments accountable, right? If you've been dealing with this person for a year trying to get records and then you sue them, it's reasonable to and then you need to sue them because they're not giving you access. It's reasonable to think this is who you sue, right? But it's not. And that's a little bit confusing. And so for both of these problems, I have a few potential solutions, right? One is there's something called Rule 4J in the Rules of Civil Procedure. Because dealing with custodians is not the only time that you have to go after a specific person at a government agency to get something you want. There's something called service of process. And if any of you have been sued or filed a lawsuit, you know that you have to serve the right person with the lawsuit. And state agencies are required to appoint their process agents. But sometimes the general statutes just say, this is the process agent. Let's just simplify this for everybody. This is the person you're supposed to sue. And so here's an example. So the process agent is the person, if you're going to sue them, you got to serve this person. State of North Carolina is the AG, cities and towns, mayor, city manager, clerk, counties, county manager, chairman, and then local boards, any officer or director. All you got to do is pull up the statute and say, this is who I sue, right? And it's not going to be a one-to-one relationship, but I think there is a way that the general statutes in the statute on custodians could say, okay, custodian of records for a city, mayor, or town manager. A custodian of records for a county, member of the county commission, county chairman, something like that. To make this more predictable and easy at the front end so we don't end up with cases that we litigate for 2 years and then get tossed. Also, there's something called agency law. And we could go down a rabbit hole with this. We're not going to do that. But agency law is where one person can be held responsible for the actions of another person. And so we have things called actual authority, apparent authority, and these are situations where Walmart hires somebody to make contracts on their behalf, right? Person they hire makes a contract, Walmart's going to be bound to it. And I think a picture is probably an easier way to see this. You have a third party, principal is going to be a corporation, agent's going to be a person who negotiates for the corporation, and the third party is the person negotiating, right? The third party can go after the agent or the principal. And this essentially just means that if you have an entity that has someone acting on their behalf, they are responsible for the things done by the person acting on their behalf. And therefore, the third party can go after the agent, the person acting on their behalf, or the principal, the person on whose behalf the actions are being taken. And so my thought is there a way to say, okay, the PIO is the one really making these decisions. If a pro se plaintiff goes after the public information officer, and it turns out 6 months into litigation that that's not the custodian, is that really going to be grounds for throwing out the lawsuit? Is there going to be some way that we can fix that to make that not a fatal claim? And so our example, NC State, if you make a public records request to NC State, you will be dealing with the public information officer. The person you actually want records from, if there's a professor, for example, that you want records from at NC State, they do not make decisions about whether they give you records or not, right? The PIO is the one who makes those decisions. The public information officer is the one you fight with. So if you as a pro se plaintiff sue the person you're actually fighting with, you shouldn't be punished 6 months down the line. Come on. And so Florida does this. They call Florida the Sunshine State, in part because they're just really good about their FOIA laws. They're really kind of on top of amending them and updating them and keeping them modern. And so in Florida, the custodian, who would be the person in charge, can just designate somebody else to permit the inspection and copying of public records. They have to publicly list who that person is that they've designated, and then that person is the one you sue, right? Seems easier to me. Another thing that you may have dealt with if you've ever filed a public records request is timing. How long does it take to turn these things around? And so under the current framework custodians have to provide access to records as promptly as possible. And if you're denied access, you can bring a public records lawsuit. What happens in the middle ground where they haven't given you the records, but they also haven't denied your request, right? Because if you don't have a denial, you don't have a cause of action in North Carolina, and if you don't have a cause of action, you cannot bring a lawsuit. Denial of access is required. Where a plaintiff fails to show that access or copies of the requested public records was denied, its case is subject to dismissal. This is 12B world, right? Defendant's going to say, you're going to sue the defendant and say, give me the records already. It's been 18 months. Where are they? Defendant's going to say, I didn't deny your records request, right? Get out of here. The Court of Appeals had the chance to answer the question, is there a cause of action for unjustified delay a couple years ago, and they just said no because they didn't have to, which is fine. There was one federal district court decision on point. Again, federal district court decisions have no precedential value, but if it's the only guide you have, it's worth looking at, right? And this was a case out of Pinehurst. It was a construction case, actually. The federal district court said the North Carolina Public Records Act does not provide relief for delay. And actually, this is a case, by the way, this is an interesting case. It's the only case in North Carolina I found where the court awarded the governmental defendant its attorney's fees because the plaintiff's lawsuit was so ridiculous. And I kind of like law as theater. Sometimes you have these cases where it's just like a lot of characters and a lot of stuff going on. I would highly recommend looking this case up. The plaintiff sent their agent to the Pinehurst town office to get records. The Pinehurst town office said to the person standing there, we don't have them yet. Agent says, I'm not leaving until you give me my records. Pinehurst has them taken out by the sheriff. Then Pinehurst gives them their records like 6 days later, right? And by the way, in the interim was Christmas. It's kind of ridiculous to sue a government and then 6 days later say, you have Christmas in the middle and say, where are my records? Why didn't you spend Christmas at the office preparing my public records request? And then after the plaintiff had their records, they then sued and said, you didn't give them to me as fast as you should have. So I don't want you to think I'm just like pro-plaintiff, governments are awful, all this stuff. This was absolutely ridiculous. But it's kind of a fun case to look at. But the point for our purposes is that the federal court just said, there is no cause of action for delay in North Carolina. And the federal court was essentially punting back to the legislature, saying if you want delay to be something you can sue about, then change the law, right? And there's creative lawyers could find ways to sue for delay. But so one solution might be to amend the Public Records Act to prohibit unjustified delay. The problem you might run into here is there's something called flood of litigation, and you don't want that. You don't want plaintiffs to sue and then to file a lawsuit and then sue 2 weeks later and say, where are my records, right? Because then predictability, efficiency kind of go out the window, right? So, again, we could look at Florida. Custodian of public records must acknowledge requests to inspect or copy in good faith. Unjustified delay, and this is case law, unjustified delay violates the Public Records Act, but down here at the bottom, delay in and of itself does not give rise to liability for attorney's fees. So they're saying, yeah, you can sue for delay, but we're not going to award you thousands and thousands of dollars in attorney's fees just for that, right? And we have some Florida case law. By the way, it's great if we can let other states do the heavy lifting, do the litigation, figure out good policy solutions, and then take their ideas, right? Some of you have heard laboratories of experimentation. We have different states trying different things. If we can look at a state that's dealt with an issue for 30 years, see where they've ended up, say, oh, it's a great idea. Just take their idea, right? So Florida said, all these are acceptable delays to determine whether records exist, to determine whether it's public or confidential, to await fees, to delete or redact, or to respond to pre-existing public records requests. So again, we're not going into the world where the plaintiff can just go crazy, file a public records lawsuit, then sue and say, where are my records? Where are my records, right? These would just, and this is case law, by the way, in Florida. If this were in the Public Records Act, these would just be defenses that a governmental defendant could list. One other thing we could try to do is provide more definition to the word promptly. Normally, how a statutory word is defined is through litigation. But as far as I have found, definition of the word promptly has yet to make its way up to the appellate courts in North Carolina. So we don't really know what's prompt, what's not. And so again, we have a state who's got a lot of litigation surrounding What is prompt, right? And they've dealt with this for years and years and years. Why not just take their ideas, right, and not have to go through what they went through? All public records shall be promptly prepared, kind of similar to ours. Failure to act promptly is not a denial, but you sue for a writ of mandamus. And a writ of mandamus is when you sue a government and say, you're supposed to do this thing and you didn't do it, so do it. My biggest problem with that, if that's what we're going to have, is that I think it'd be tough for a pro se plaintiff to sue for a writ of mandamus. It's a pretty complicated legal proceeding. So you'd probably have to go hire a lawyer, which is expensive, which a lot of people trying to access public records just can't do. They've said promptly means without delay and with reasonable speed. Whether access is provided promptly is a question of fact. And again, they've done our work for us. Don't try to read all this. My point is, though, Ohio has done some of the work for us in defining what does promptly mean. They have examples of when access was provided promptly and examples of where access was not provided promptly. And I don't think any of the examples are really ridiculous on either side. I mean, we had a city was asked to provide financial statements. They gave them a week after the request, and then they were sued, right? That plaintiff, that's ridiculous. You shouldn't sue a week after you filed your request. 12 days, but over here we've got where a government didn't even respond for 2 months, right? That's not prompt. If we could incorporate these ideas into our framework, we wouldn't have to go through this, because each of these lawsuits is years, right, to get to this point. And again, we're going for breadth, not depth. So I know I'm kind of skipping across the top here, and there's a lot more to each of these. Another problem is, when does a plaintiff get their fees in North Carolina? By the way, another issue I've researched is, when should a government get its fees? I just didn't think I'd be able to fit both those in today. So why do we award attorney's fees? North Carolina generally doesn't award fees to plaintiffs. If you want your fees as a plaintiff in North Carolina, there has to be a statute saying, in this kind of lawsuit, you get your attorney's fees, right? That's as opposed to Arizona, for example. If you're a plaintiff's lawyer, you would love this. They have this nifty thing called the Private Attorney General Doctrine, where if you are enforcing the laws, then you get your fees, right? So there's a Goldwater Institute. John Riches was here last week. Goldwater Institute, they get a lot of fees out of this because they enforce a lot of laws. But the purpose of fee provision is to provide incentives for members of the public to seek enforcement of their right to inspect public records, right? The idea is, I can't afford a lawyer, but I think I have a really good case. A lawyer might say, okay, fine, I'll take it. I'll take your case. You don't have to pay me. And then if we collect fees at the end, then I'll get paid, right? Our fee statute says a plaintiff who successfully compels production of public records shall recover its reasonable attorney's fees if attributed to those records. And this is the part that I really care about. If the plaintiff substantially prevails. What does that mean? Added in 2010, there has not been one case at the Court of Appeals litigating whether a plaintiff substantially prevailed for the purposes of a public records lawsuit yet. And it's been about, which is interesting, because you look at some states and they have quite a bit of litigation about this. We just don't have any. And so a big question then is, if you don't have binding case law to look at on an issue, you look to other states, you look to other jurisdictions, right? The Federal Freedom of Information Act also awards fees to a plaintiff who substantially prevails. And so you might think, oh, well, maybe we can look at all the litigation, because there's a ton of litigation surrounding whether a plaintiff substantially prevails under the federal statute. Anybody heard of Judicial Watch? They're an organization. Yeah, Judicial Watch is litigating this a lot, and they get a lot of fees under the Freedom of Information Act. So we had this case back in the 80s, Spangler. Spangler, some of you might remember, was a president of UNC back in the 80s. And the North Carolina Press Association, who back then was not, now Amanda Martin represents them, right? Back then, they were with a law firm, one of the big law firms in Raleigh, Tharrington Smith. And the defendant produced the documents, but then they said, we didn't produce them because of your lawsuit. We produced them because we were always going to produce them. We just needed a little more time. And the question is, does the plaintiff have to show that their lawsuit caused the release in order to get their attorney's fees, right? And remember, this is important, because if you don't think you can get attorney's fees, you're not going to sue. If you think you can get attorney's fees, you're more likely to sue. The defendant says, the Federal Freedom of Information Law says the moving party, moving mean the party seeking fees, has the burden of showing that the lawsuit caused the agency to release the documents. And in the 80s, they said, we don't look to the federal FOIA. FOIA means Freedom of Information Act, right? In the 80s, they said, we don't look at the federal act. And so the question is, does that mean now in North Carolina we're stuck? We just can't look at the federal act for guidance. We have no appellate case law on point here. What on earth do we do? I think it gets a little more complicated. And this is where we get into, some of my research has been on looking at the legislative history of the North Carolina Act and the legislative history of the federal FOIA and saying, okay, have they tracked where they were in the 80s and therefore the Spangler case is still on point, or have they changed? And so now we have our, back then it said a party successfully compelled the disclosure of public records, gets reasonable attorney's fees. In the federal FOIA in 1989, reasonable attorney's fees, where the party had substantially prevailed. Now, in North Carolina, we have the substantially prevailed language, but the federal FOIA has totally changed. The point of this, this is a lot of text. The point to take from this is the Federal Freedom of Information Act did a big change in 2008, where they amended the law to say, if your lawsuit is the catalyst for the production of records, even if there's no court order saying produce records, then you can get fees. So if you sue an agency, you scare them, they give you the records, you can get your attorney's fees, right? And this is largely thanks to organizations like Judicial Watch, right? And if you look at the case law now, Judicial Watch just gets, you have fee case, fee case, fee case, fee case, all the way down Judicial Watch. So the point being, this is the federal, this federal standard down at the bottom right is very plaintiff friendly. Plaintiff sues, government backs down, you can get your fees, even if you don't complete your lawsuit. I cannot find a compelling reason that North Carolina cannot any longer look at the Federal Freedom of Information Act, right? I can't really find a super compelling reason that we must look to the federal act, but I just kind of think that Spangler case, the laws have changed so much since 1989 that I just don't think that statement of law that we don't look to the federal FOIA anymore, we can use that anymore as binding case law. And so what we really have to do in North Carolina is pick. And when I say we, I mean either the legislature, and if not the legislature, the courts are going to have to pick, because the courts have to decide what does substantially prevails mean. There's no case law, and there's not a lot of legislative history. And so I found two directions we could go in, two kind of different directions. So Texas says a plaintiff shall receive its attorney's fees where it substantially prevails. Federal says court has discretion to award fees where plaintiff has substantially prevailed. And that includes a change in position by the agency, right? I think you could look at these two, and one's mandatory, one's discretionary, but they're not necessarily that different, but the meanings that they've been interpreted as are very different. In Texas, you cannot get your attorney's fees as a plaintiff unless a judge issues an order saying produce, right? If the day before the judge produces an order saying to give over records, the government says, here's your records, plaintiff can't get fees, right? In the federal system, if you sue a governmental defendant and they back down because of the lawsuit, you can get your fees. And again, just reiterating, this might not seem that important, but it is very important because fees are an incentive. You incentivize conduct, you get more of it. You disincentivize conduct, you get less of it, right? The Texas model, if we're going to choose, has been widely criticized to the point that this summer, the Texas legislature tried to change this and the governor vetoed it. A lot of groups, a lot of conservative and liberal nonprofit groups in Texas have widely criticized this because basically governments can just delay, and then if you say, I'm going to come after you for fees, they go, oh, well, here you go. And then you're stuck, right? I also think that the federal model makes more sense considering the small amount of legislative history we have, because the substantially prevail standard was added as part of an act to strengthen transparency. And if we say that this 2010 law essentially enacted the Texas standard, I have no idea how that increases transparency. It doesn't. If anything, it decreases transparency. But we talk about predictability, right? As somebody who's been on the plaintiff side of this, you just don't know how to get attorney's fees, right? And something if we were to go more in depth on this, I could show you that substantially prevails language. Different states have interpreted it totally differently, right? Some say if you're going after 100 documents and you get 70, you've substantially prevailed. They just say number of documents. Some states say it's the importance of the document. So if you only get 20, but you're going after 100, but the 20 are really important, you get a smoking gun, then you get your fees, right? Nobody wants to be the person who says, I'll be the test case. I'll spend 2 years of my life litigating, go to the Court of Appeals, and then see if I'm going to get my attorney's fees, right? Nobody wants to do that. And so, unfortunately, we may just have to do that, unless the legislature provides more clarity. And again, I know we skipped across a lot of different topics. If there's anything that I talked about that you go, ooh, that's something I'd like to know a lot more about, I do have a lot of research on this going way more in depth, and I'd be happy to send you anything you'd like. But I'd be happy to take questions if you have any. Yeah?
Early on in your talk, you mentioned that my communication to Senator Berger's office, for example, could be subject to a records request. I wonder if you'd clarify that, because I think that the legislature has exempted all their communication with anyone outside the legislature or within state government from any record requests.
If they've exempted that, then I hadn't heard of that exemption. If it's exempted, then yeah, it's exempted. I just hadn't seen that exemption. So, when did they do that?
I don't think it's at all new. I think that has been, if not the law, the long-standing tradition, and I know it's founded on some law or principle which I'm not familiar with. But they persisted. They normally, in virtually all cases that I'm aware of, if you try to FOIA them, they will say we're not subject to that.
Okay. Well, maybe a better example then would be there was a new Raleigh City Council member a few years ago who decided they were going to set up a Gmail account so constituents could email them not at their government address, and it wouldn't be subject to FOIA. And it was just, for at least for a Raleigh City Council person, you can't do that. Because they're subject to the public records law, and it's not whether it's your government email, it's whether you're discussing public business. Yeah. Yeah.
Or text messages public records.
Yes.
How do you know?
Because they're documents made or received in the transaction of public business.
Do government employees who work in the executive branch consider text messages to be public records and retain them and use them when you ask them?
They are supposed to, and there hasn't been a lot of litigation surrounding this. Just now, there's litigation with the Union County Sheriff's Department about deleting text messages. I see no reason they're not, if they're not specifically exempted, right? And as for executive branch employees, I see no reason that they would be specifically exempted unless there's, again, an exemption I'm not aware of. But they are, I'm not going to go all the way back to the beginning, but they're records made or received in the transaction of public business. Now, granted, even if you're on your government phone and you text your wife and say, what do you want for dinner? That's not a public record, right? Because you're not discussing public business. But yeah, the Department of Archives also prescribes regulations for government employees having to retain documents, and that includes text messages and emails.
And yet the state government largely relies on the employee themselves to produce those public records. The same with emails to private email accounts. They're required to be produced, but they largely rely on the employee to produce them.
Or coaches at large universities.
And yeah, I mean, and this is stuff that, these difficult issues that are being litigated, the question is who's going to sue and fight it and then try to get fees at the end. Yes?
I'd like you to talk about the relative value of having things protected or available via public records law or via more explicit statute about transparency about what must just be regularly disclosed. For example, if I want to know what the English department at UNC Chapel Hill spends annually, I have to do a public records request because that information so far has not been produced, even though they are in fact supposed to produce such things. I guess my question is, when should we just fall back on, well, you can request that if you want it, and when should governments be compelled to make things publicly available just all the time?
So it's a good question. First off, in terms of requesting things like how much do you spend, they don't have to keep like records of how much they don't have to keep records of how much they spend for the purposes of answering public records requests. So the law doesn't require them to. The public records law in no way requires governments to make new records, right?
Well, there's a transparency provision in the 2015 budget bill that requires financial transparency down to constituent levels.
And so you'd ask not how much are you spending, you'd say I want to see those records, right? I mean,
regardless, they so far have not produced such a thing.
when did you ask?
Not recently because I've been actually just
Okay.
talking to them about it, but they're installing a new data system
Yeah.
that they can do that.
Okay.
In any case, I want to hear more about
Yeah.
the general principle of.
I like the idea of governments just having to put stuff out there that you can look up online. There's been the idea of having government emails all just go into a system, and it's up to the government employee at the beginning to say might be confidential, then they click it, goes to somebody who reviews it, maybe the public information officer. Again, I don't have hard data to support this, but I've thought that maybe if government emails in particular just went into a database, that could save everybody a lot of time, because then you wouldn't. Because the way they have it right now, you request a bunch of emails from a government, they put it in this computer program, and the program just whirs for like a week and searches through and sees if it finds anything responsive to your request. So I like the idea, yeah, of them just having to put stuff out there. I think you'd have to. I've talked with some PIOs. You know, I've always been on the plaintiff side of this, and I've started talking to some PIOs, and they are. It's easy when you're on the plaintiff side to be like, give me those records. Why aren't you giving them? They are pretty busy. And so I think if you're going to give them more responsibilities, we'd have to figure out some way to mitigate the other stuff they have to do. But it's a good idea. Yeah, I mean, as a policy idea, it's great. Yeah. Yes?
Facebook. For information, for public record, is Facebook, even if you put privacy settings on it, is that still information that can be extracted to be used?
If you are discussing public business, then it's a public record, right? And so the next thing I'm writing is about Facebook and Twitter and all that, because really it doesn't squarely fall. The public records law wasn't written for Facebook and Twitter. It was written for basically letters and, you know. Yeah, if you're discussing public business, it's public records. I see Senator Jeff Tart all the time on his Facebook will have basically like forums with citizens online, right? And those are all public records. So if you're working in government, I would say maybe have like a page that's your government page and have a page that's like your private life page. And I would just keep those separate. I think it's the safest way to go. Because I know that might be frustrating, but if you're discussing public business and you're sending messages back and forth, those are public records under the law. Yes?
And the second part of that is one of the behind-the-scenes things with Facebook is that's a data mine of storage of all of our information.
Mm-hmm.
What Facebook does or doesn't do with that, I'm not them, I don't know. But government may be able to take that information at some point in time, now or down the road, and gain all that. If they do, then is that considered public record?
So you're saying if government gets
My own private Facebook page.
your own private Facebook page, if the government like takes it,
Server stored all of my data
Mhm.
under my name. Now or into the future, whenever this takes place, and it's out there in discussion, can that become public record where they can go in and take government and take my personal information of sharing something with a relative, a friend, whatever, instant message? Can that be
oh, I see. Okay. So I was thinking I thought you were talking about public officials discussing public business on Facebook. If you're just talking about a private person's Facebook,
Because it's all stored on a server.
I see no reason right now to think that private Facebook stuff would be public record.
It's kind of rumored out there that it's kind of the reason, the core point behind Facebook, but I don't want to be on record saying that.
My hope would be that we have a legislature, and if suddenly that becomes a fear, we can work with the legislature to deal with that and say this stuff's not subject to the law. I don't know that the North Carolina Public Records Law is really the solution for that, though. Yeah. Yeah.
Professors at university. I know it's been an issue in Virginia, with lawsuits related to Michael Mann.
Mm-hmm.
But work that they do, or work that's government funded in even private universities, is that subject to a record request in North Carolina? It's probably different in every state. Data sets that are used for underlying research, that sort of.
So I know of no, if they're state employees, like NC State, UNC professors are state employees, it's the transaction of public business. But the Court of Appeals has said that documents that you create pursuant to lawful duties are all public records. So I think a public university professor teaching is a lawful duty. I know of no exemption that would say that a professor's emails are not public record. And in Virginia, I have a friend, Matthew Harden, is a FOIA attorney up in Virginia, and that's what he does. He basically goes after professors' emails in FOIA suits. So.
I'm thinking of the research itself. I mean, going out and collecting a huge amount of data for some paper. Or
Yeah.
whatever. And very often they're protected.
I-
They put it all the word.
Yeah.
Can you get, through a FOIA request, can you get that data?
I know of no exemption, and assuming there's no exemption, yes, you can. Because they are state employees performing lawful duties, and therefore what they're producing are public records. And you know, the questions that we're asking, this is why we have statutes for this. It's really a policy question of, do we want that kind of stuff to be available? And so some states, states can say this particular thing is not a public record and then exempt it. But as far as I know, we've not done that in North Carolina. But you do have to ask for a specific document, right? You can't just say, you can't ask a question, you have to ask for a thing, if that makes sense. So, but you're talking about data sets and stuff, yeah. Right?
Is there any liability if they release a document or record that's not a public record? Like you request public records from the town of Cary, they release something that's confidential, and the person whose confidentiality was breached?
Usually no, except in the world of personnel. And that's why in personnel lawsuits, a lot of times governments will say, sue me, whatever. I was against a guy named Brad Klein, who's an attorney in Charlotte. He's a great attorney. And the first time I was suing them for documents in Belmont, right? And he was worried, what if these are personnel? Because if you do disclose an employee's information that's supposed to be confidential, you as a government entity could be in trouble. And the first time we talked, he basically said, look, if the court says I have to give it to you, I'll give it to you. But I'm protected by that court order. So yes, in some cases there can be. Usually the exemptions are just things the governments can claim. So exemptions like, I don't know, like certain contracts between port carriers and stuff like that on the coast. I don't see them, they're not liable for production. But mostly in personnel though. Producing, if you produce, if I asked for the health records of a state employee and they gave them to me, the agency would be in trouble. Yeah. Yes? Yes. The federal law only applies to federal entities. The state law only applies to state entities. Yep. Good question, though.
Oh, you mentioned collection of attorney's fees as one of the penalties for noncompliance on the part of the government agency. I'm just wondering if you looked at other states and how North Carolina compares perhaps to penalties for noncompliance on the government side. In other words, we sue, the government should have turned over the information, they may have to pay attorney's fees. Are there other states that have other kind of penalties for noncompliance?
There are states that will say that at some point noncompliance could be a misdemeanor or something along those lines. I don't know that I really like that because I think if you're going to be guilty of a crime, there should be intent. And I think a lot of times these government officials aren't necessarily intending to break the law. They just don't really know what to give out and what not to sometimes. But in terms of, because the attorney's fees are the penalty, essentially, which is a little bit weird because at the end of the day, it's not the people's pockets at the agency, it's taxpayer pockets. But in terms of how much states have to pay out in attorney's fees, there are states where plaintiffs get a lot more in fees than they do in North Carolina. Mostly because it's litigated on a more regular basis. And in North Carolina, it's just not as litigated as much.